Hello friends, a very warm welcome to our legal channel Duasnduas. Today we are going to discuss a very important and interesting topic, the important aspects of Prevention of Corruption Act 1988. Recently we dealt with one of the matter relating to Prevention of Corruption Act, and it came to the light that there is a lot of confusion into the minds of litigants and public servants with respect to the essential ingredients. So, in order to assist and help our viewers, here we are discussing important aspects of Prevention of Corruption Act. The first aspect which must be discussed is about the concept of public servant and public duty. Before that, it is important to point out that Prevention of Corruption Act was enacted on 9th of September 1988. Prior to that, there were certain other provisions. We are not discussing about them. But since 9th September 1988, the Prevention of Corruption Act 1988 is into the effect. Now, as per this act, before coming to the concept of public servant, it is important to discuss public duty, which has been defined under Section 2B of the present Act. What is public duty? Now, why this public duty we are discussing is a large concept and the canvas is too large. It's important to understand this. Duty in discharge in which either the state or the public or the community at large has an interest is public duty. And public servant, as per Section 2C, subclause 8, who is doing public duty, any person is a public servant. Now correlate these two concepts, that any person doing the public duty is a public servant. Any person doing the public duty is a public servant, which means it is not necessary that the person must be paid by the public exchequer or he must be a government employee. There is a difference between government employee and public servant. We're talking here about public servant. As far as Prevention of Corruption Act is concerned, public servant can be booked under provisions of Prevention of Corruption Act. So any person in discharge of public duty is a public servant. Concept 1 is clear. Second concept that we are supposed to talk about, the offense of bribery as per Prevention of Corruption Act. Here, the proof of demand by a public servant is sine qua non for establishing offense under Section 7 of the Prevention of Corruption Act. Without proof of demand, even recovery of tainted money will not stand the test of law, and the offense will not be made out in front of the court during the trial. Offense, the demand is really important. The proof of demand is important. For example, we were going through one of the matter whereby Supreme Court held that even the recovery of tainted money from an accused person without the proof of demand will not constitute the offense under Prevention of Corruption Act. So it means in trap proceedings, the recovery of money, tainted money, or the bribe money, or the consideration is okay, but it has to be coupled with the evidence of demand. For example, I was just going through one of the judgment whereby an accused person was caught red-handed with some amount of bribe money. Now, the allegations of prosecution were that the engineer was demanding money for clearing invoices raised by the contractor. So X amount was paid by the contractor to the engineer, and the engineer passed on that money to co-accused. and the co-accused was merely present there. He took that money from the engineer, who was another accused, and kept that money in his pocket. During the trap proceedings, the money was recovered from the co-accused, who was merely present there. So the Supreme Court held that the recovery of tainted money from the co-accused without the evidence of demand is of no use. I again reiterate this thing, that the proof of demand by a public servant is sine qua non for establishing offense under any provision of the Prevention of Corruption Act. Now, the third and the last important aspect, which leads to confusion to lot many litigants, even advocates, is the grant of sanction is really important for booking a public servant. Honorable Supreme Court, while speaking through Honorable Mr. Justice D.Y. Chandrachud in Criminal Appeal number 697 of 2021, State of Kerala versus K. AJITH, has settled this proposition that any public servant who was not doing the official duty or has demanded, or there are allegations of corruption against the public servant not discharging his official duty, in those cases, sanction is not required. Let me put it that way, that in a person, a public servant in discharge of official duty cannot be prosecuted if there are allegations of corruption without the sanction, without the grant of sanction by the competent authority. But if a public servant during discharge of his non-official duty, or he was not doing his official duty, and there are allegations of corruption during that whatever duty he was performing, but it was not official duty, then sanction is not required. To put it that way, an MLA, there are allegations against a sitting MLA of receiving money or demanding money, or there are allegations of corruption against a sitting MLA for granting ticket in the ensuing elections. Now that MLA is not discharging his official duty, so sanction is not required to book him under the Prevention of Corruption Act, because he was not doing or discharging his official duty. The allegations of corruption are not during the discharge of his official duty. With this, we rest for today, and thank you for watching this video. Next topic will be uploaded very soon. For any advice or consultation, please contact us or visit our website to book the consultation. I am happy to help. Your legal expert, Duasnduas, signing off. Thank you.